Hello and welcome to the sixth session of the Building Safety Act 2022 CPD series, provided and presented by the Institution of Structural Engineers. This session is being recorded for reference and sharing purposes. CPD is crucial for structural engineers as it ensures they remain up to date with evolving industry standards, technologies, and regulations. With the introduction of the Building Safety Act 2022, structural engineers must stay informed about new safety protocols, risk management practices, and legal responsibilities. My name is Human Bagi, and I'm hosting the CPD series as the chair of the Southeast Super Region, comprising 4 hubs as annotated on the map. Light purple area on the map shows where we are, who we are, and how we can support our members. For help and support on technical matters, CPD's webinar, training, courses, and many more, please visit the institution's website or contact the HQ. For those who would like to watch the previous sessions, they are available on the institution's regional website, as well as the YouTube channel highlighted in blue. Please send questions via the text message box, which will be answered either during or after the session. This presentation is the last one of the series and has 2 parts. Part 1 includes an overview summarizing the responsibilities of the structural engineers highlighted throughout previous sessions, and Part 2 has more details and talking about the legal issues and liabilities presented by Mr. Mark Scotney, partner at Clark Wilmot. Learning outcome and overview of this session is highlighted, as you can see. During the previous 5 sessions, liabilities, accountabilities, responsibilities, and duties were discussed. BSA significantly enhances the accountability of all parties involved in higher risk buildings in construction and in use, which is highlighted in yellow, including our structural engineers, by extending the duration of the potential liability for defects, allowing for transfer of liability within corporate groups, and introducing stringent penalties for non-compliance and providing false information. Members should be aware that their work could be subject to long-term risk due to defective work, longer period, like 30 years now, taking risk when specifying products, incorrect information submission may lead to prosecution, and working on HRB will face much more criticism and demand. How to mitigate exposure by understanding key responsibilities before commenting any work or commencing them. Comply with the obligations, consider liability when designing, and be aware of legislations and enforcement, which is including I/D sanctions. All previous CPD sessions covered each item circled in this graph, which are related to high-risk building as well. I/D has published many documents, including 2 very important guidance and many other essential helpful documents under the Building Safety Act page of the website. Top left a screenshot is the web page, and the first link takes us there to search and find more useful resources as well. 2 publications are Assessing Higher Risk Building on the Building Safety Act, a compendium of the structural typologies, which is the blue one on the bottom right-hand side, and the structural submission for higher risk building under the Building Safety Act guidance for Gateway 2 and 3, the green one on the top right-hand side, which is recommended to structural engineers and those involved in building control checking. The criteria for determining whether a building falls on the HRB or not, in addition to our instructive publications, The most comprehensive guidance is on the government website. The second link directs us to the website as shown by the screenshot in the bottom left-hand image. During session 2, it was which was presented how important the competency is and how iStruct is involved in creating, regulating, and managing the register for those who work with HRB. If interested, in addition to iStruct guidance and information, there are other publications by HSE related to principal designer and principal contractor. During session 2, my colleague discussed about PAS 8671 related to the competence of principal designer, and PAS 8672 related to principal contractor specifications. A gentle reminder that the competency is one of the key requirements of the institution, clearly indicated in the Code of Conduct and bylaws, as shown in Article 4 and 5 and Section 6.3. I'll let you read it. Also, there are several guidance and helpful notes on business practice notes series published in the Structural Engineering iStruct magazine, which are recommended to read them. Any questions or anything on that would be answered within those publications. They are very helpful and contain significant amount of information. The responsibilities and duties have been mentioned throughout previous sessions. I'd recommend watching the recorded CPD sessions if you're in doubt or have any questions. This is a schematic of the enforcement based on building safety regulator determination in green, offences and penalties in pink, and other enforcement in blue, including the iStruct prohibition highlighted in red as part of the industry and regulator sanctions if non-compliance is deemed serious. I now hand it over to Mark to introduce himself and share his presentation. Thank you.
Thanks, Human. Good afternoon, everyone. So I'm Mark Scotney. I'm a partner in the construction team at Clark Wilmot. So I'm a disputes lawyer specialising in construction claims. And through that, I've got significant experience in handling building safety related claims. So I currently represent various social housing providers, developers and contractors in relation to those claims. And so I see the issues we're going to discuss today very clearly in the context of the risk posed to the design team and how possible claims could be advanced against designers and structural engineers. So in terms of the learning outcomes for today, the hope and intention is to give a broad overview of the key principles of the Building Safety Act with some practical and specific focus for structural engineers and their roles in construction projects. So I'm aware that some of you will have attended the previous sessions within the series, and the hope is that the content of today's talk will build upon what you've already learnt and will be useful for you to put into practice. So in terms of an agenda, broadly I'm going to work through with you an explanation of the key definitions and terms arising under the Building Safety Act, to consider the liabilities which arise under the Building Safety Act, and specifically the exposure to those liabilities which may impact upon structural engineers and how you can mitigate that risk when you are being appointed and working on relevant projects. So I'll begin by giving a relatively brief introduction to the Building Safety Act. I won't spend ages on this because I suspect much of it has been covered off in the previous sessions, but I think it's important for me to give some background from my own legal point of view. So as I'm sure you're aware, the Building Safety Act came into force back in April 2022. And in the 3 years since then, we've seen a number of pieces of supplemental legislation and regulations being brought into force. As we all know, the policy reasons for bringing in this new legislation is to fix the issues arising out of the Grenfell Tower tragedy, which exposed significant malpractice in the construction industry. So it's fair to say that the Building Safety Act raised some eyebrows in the legal sector because it made a number of significant changes to existing legislation, and in particular by extending limitation periods retrospectively. So the Building Safety Act introduced an extension to the scope of the Defective Premises Act, which applies to all dwellings in England and Wales and enables the owners or anyone with a legal or equitable interest in the property to pursue a claim for defective works where the work renders the dwelling unfit for habitation. So the Building Safety Act expands that scope so that it now also includes refurbishment works. Previously, the operation of the Defective Premises Act was limited to new builds, new dwellings, and it's now to also include refurbishments. And as I mentioned earlier, the significant change is that it extends limitation periods for 30 years retrospectively for claims arising before June 2022 and 15 years for claims accruing after the 28th of June 2022. So these changes were introduced to allow building owners and occupiers to bring claims for historic defects and ultimately to hold liable those accountable for the defective works. But as we've seen in the case of URS versus BDW, it also enables developers to pass on claims to the design team for claims arising under the Defective Premises Act within the extended limitation period. And I'll touch on this only very briefly, but the Building Safety Act also introduced the new building liability orders, which now allows parties to pursue others who are not a party to the original underlying contract. So, for example, a typical example where you've got an employer and a contractor in one contract, the building liability, pursuant to a building liability order, you may be able to progress a claim against the contractor's group companies. And of course, the ability to bring such claims goes against the rule of privity of contract, pursuant to which you can only sue the party you are in contract with. So the introduction of the building liability orders widens the pool of potential defendants significantly. And for that reason, it's relatively controversial, but it's designed to stop parties from avoiding liabilities by using SPV companies or via insolvency. So both the extended limitation period for claims under the Defective Premises Act and the introduction of building liability orders means there is now the potential for a much greater scope of claims against construction professionals to include structural engineers and linked entities, and an increased limitation period within which to bring such claims. So with that context in mind, the focus of the rest of the talk is going to be about the new obligations and requirements which are placed on those involved in the construction of new buildings and to existing buildings, to include a particular focus on the new duty holder regime. So please forgive this, this current slide, which is a fairly dense table which provides a summary of the key legislation. I thought it'd be useful for you to see and have as a reference point to look back at, given the number of different new regulations that now exist and the difficulty in piecing the various pieces of legislation together. So I'm not going to begin to go into the detail of that during this talk. And as I say, hopefully, if you need to, you can refer to it later. But instead, I now propose just to run through quickly the key definitions, rules and principles which derive from the legislation itself. One of the key definitions is higher risk buildings. And of course, it's really important for structural engineers to identify projects which are going to involve a higher risk building. Somewhat unhelpfully, within the various regulations, there's different definitions of higher risk buildings. But in summary, we can boil it down to two. The most likely and common definition we'll need to refer to is for the design and construction of a new building. And so the definition for that is fairly straightforward. So it's a building with at least 2 residential units or a care home or a hospital, which are at least 18 metres in height or have 7 stories. There's a slightly different definition for buildings which are in occupation. And buildings in occupation, the starting point of the definition is the same in that it's a building with at least 2 residential units and or at least 18 metres in height or 7 stories. But the importance is that it's got an exclusion for hospitals, care homes, secure residential institutions, hotels or military barracks, etc. So as I say, it's really important for structural engineers to identify projects where they're going to be working on a higher risk building. And so those definitions are important. I touched now very briefly on accountable persons, the definition of accountable persons. I've included this for completion and to avoid any confusion with the other duty holders. So accountable persons are separate from the construction team, and they are those organisations who own or who have responsibility for the occupied high-risk buildings. So this will apply generally to the housing providers, and it will not generally apply to you as structural engineers in your capacity working on new projects. The duty holders then, so they are the client, the principal designer, the principal contractor, designer and contractors. And the BSA has introduced the duty holder regime, which sets out these new roles which need to be filled when carrying out new construction work and work to existing buildings. So the new duty holder regime doesn't apply just to higher risk buildings, but to all projects. And the duties span the whole project from the design phase right through to completion and beyond. These duties are also confusingly named the same as the existing roles under the CDM regulations. And I'll go into that in a bit more detail later, but the roles and duties are not the same as the CDM and need to be considered separately. The BSA introduces the new concept of the golden thread. And this, in summary, this concept requires the parties, that is the duty holders, between them to put in place systems and processes to ensure that the construction process and key information about the building is recorded and stored electronically in such a way so as to ensure it can easily be accessed and referred to. There's also mandatory occurrence reporting, which I'll go into later in the slides, but it's important to note that the golden thread and mandatory reporting only relate to higher risk buildings. I mean, to my mind, much of what's required by the golden thread is not particularly new and was probably being undertaken in a perhaps more haphazard way on previous construction projects, but the new rules provide more formality as to how this record keeping should take place. So what are the duty holders' responsibilities then? So the duty holders are collectively responsible for ensuring that the completed buildings are safe to occupy, and this applies to work on existing buildings and new construction. So by way of example, we're currently negotiating an agreement for a contractor to remedy defects on an existing building. And as part of that agreement, there are negotiations regarding the duty holder regime, which will apply to those remedial works. It's important to note that the duty holder roles can be assigned or applied automatically. So structural engineers should take care to understand what is being expected of them under the terms of any appointment, and to ensure this is clarified at the outset of any project. It would be prudent to ask and understand which other relevant parties are involved and which parties are taking, and what roles each of those parties are taking on. I've seen this referred to as a design matrix. Structural engineers must also ensure they have the necessary skills and competencies to carry out the specific roles that are being requested of them. And again, the form of appointment must accurately define the scope of works and the role being undertaken. The duty holders as a group are required to work together and to collaborate to manage and coordinate the design and construction of the works being carried out. And for me, the use of the words collaborate and coordinate set off some alarm bells, because the duty to collaborate can, and I think will, blur the lines between the different consultants and contractors working on the design of a project. And so the culpability of one could be pushed onto another on the basis of a potential lack of collaboration. So this is something to be mindful of as a structural engineer at all times. And I fear it may present some challenges to compliance. To my mind, therefore, it's important to consider who the fellow duty holders are going to be and whether those fellow duty holders are likely to pose any specific risk or challenge when viewed through the lens of collaboration. So So moving on then to the specific responsibilities for the duty holders, and the focus on what I'll talk about is the principal designer. So as I mentioned earlier, the principal designer is not the same role as under the CDM regs, as these roles now coexist, but it will often be the same parties taking on the same role, but not always. So the role of the principal designer under the BSA will be taken out by somebody specifically appointed, usually the lead designer. But if no one is appointed, it can also defer to a non-specified party who fulfills the criteria for the role. So it's worth noting here that one of the potential consequences of the BSA may be claims against professionals, to include structural engineers, who perhaps unknowingly assume responsibilities as the principal designer under the Act without appreciating the obligations this entails and without having proper qualifications for compliance. So when we're considering higher risk buildings, the client is required to appoint the named principal designer. And of course, this is the important role which involves influencing how risks to health and safety are managed throughout the project. And as recorded on the slide, this will include design management, so the duty to plan, manage, monitor the design works to ensure compliance with building regs and other applicable standards. It introduces the duty of coordination, so the duty to coordinate with other duty holders to ensure safety and compliance, and helping and advising the client in bringing together the pre-construction information and providing information to other designers and contractors so that they can carry out their duties. The duty of coordination also entails working with other designers on the project to eliminate foreseeable health and safety risks to anyone affected by the work, or indeed to take steps to reduce or control those risks. So the principal designer should ensure that everyone else involved in the pre-construction communicates and cooperates with one another, and by coordinating their work. As I say, this seems to be a significant burden and one that could lead to exposure and claims for the principal designer. There's also the obligation to share information, and for higher risk buildings, the principal designer should also implement processes for mandatory occurrence reporting, which is something I'll consider later on. I'll touch only briefly on the responsibilities for the principal contractor, but again, whilst the title is the same as the CDM regs, it's not the same role. So the principal contractor in the context of the Building Safety Act is a role during the construction phase and beyond. And the responsibilities as recorded on the slide include planning, managing and coordinating. It requires cooperation and communication with the principal designer and the client and other contractors, and the duty to assess the building work to make sure it complies with building regulations. As for designers and contractors and clients, as recorded on the slide, they also have obligations to ensure compliance, coordination and cooperation. And I'll move on in a couple of slides' time just to compare the difference between the responsibilities for a designer as against a principal designer. So the key challenges for structural engineers within these various roles, as I see it, will be managing the coordination and information sharing obligations. We're already seeing situations where parties are refusing to take on responsibility for certain things, and presumably coordination obligations increase the risk of claims against multiple parties, as it blurs the lines between each party's obligations and the role to a certain degree. So structural engineers should take care to ensure the terms of their appointment are absolutely clear, including, crucially, the scope of works and clearly defined roles, if any of the duty holder roles apply. Record keeping will be an essential component to demonstrating compliance. And to my mind, you're going to need to approach projects with a mindset of looking ahead and asking yourselves, could we prove and demonstrate our compliance with our obligations if asked to do so in, say, 12 months' time, or 2 years' time, or 15 years' time? And so record keeping is going to be key, and keeping records for longer is going to be important. So this slide intends to draw out the distinction between the roles of the designer and the principal designer under the Building Safety Act. So broadly, the designer is any person who carries out any design work or arranges for or instructs someone else under their control to carry out the design work. And so that will almost certainly be the role of the structural engineer at the minimum. And you'll be responsible for design work, coordination, and ensuring that complies with the building regs and the relevant requirements. But as a structural engineer, you may also be the principal designer. And the principal designer is appointed to coordinate the design work, manage and monitor the design process, and ensure overall compliance with building regulations and safety standards. So whilst the individual designers are responsible for compliance with their specific design work, the principal designer takes on a broader coordinating role regarding the wider design. So there's no doubt that as duty holders, both the designer and the principal designer have extensive statutory obligations and responsibilities, each of which creates additional risk, liability, and exposure. So I touched on this earlier, but I think it's something worth flagging again. But there's a key risk caused by the potential automatic assignment of the role of principal designer. So it's the client's responsibility to appoint the principal designer. And whilst there must be an appointment for Gateway 2 for higher risk buildings, if no appointment is made, then the automatic assignment there is an automatic assignment to the designer in control of that design phase. And in the context of a domestic client who doesn't appoint a principal designer, then the designer in control of the pre-construction phase of the project automatically becomes the principal designer. So these are default assignments, meaning it happens by operation of the regulations if the client fails to make the explicit appointment. And this could easily apply to structural engineers depending upon the nature of the project and what they're doing. So again, steps must be taken to take care to clarify at an early stage and make sure you know exactly what is being expected of you and that you know who the other duty holders are on the project. I'll talk a little more about those liabilities and how to minimise exposure shortly. So before then, I just want to explore the additional exposure on high-risk buildings. So parties working on high-risk buildings need to justify their professional competence to work on high-risk buildings. And this is likely to be through the establishment of discipline-type registers, which I'll discuss in more detail later. But even those not involved in high-risk buildings should be aware of the scope so as not to be in breach of their duties. So the principal designer and the principal contractor need to be specifically appointed by the client before Gateway 2. And again, I know I'm repeating myself, you should always take steps to make sure you are clear on the role and that it is properly defined in your appointment and scope of works. And for high-risk buildings, in addition to the golden thread, which I referred to earlier, there's also mandatory occurrence reporting, which will apply, which I'll go on to discuss now. So mandatory occurrence reporting is something which applies to high-risk buildings only. And it's basically a system that requires the primary duty holders, that is the primary designer, and so the principal designer and principal contractor, to report safety-related incidents and risks to the regulatory body. So this system aims to capture and address potential hazards that could lead to death, serious injury, structural failure, or fire safety-related issues, ensuring prompt action to prevent harm. Examples of such would be if you became aware of a non-compliant product being used, or inappropriate or incorrect installation of products or materials, or the realisation that there may be a design flaw. And of course, the process is designed to encourage proactivity and transparency and to prevent people from covering things up and to hold those accountable. So in the example of Grenfell, we all know that it has become apparent that numerous companies and individuals knew of issues but kept quiet about them and didn't do anything about it. So as a structural engineer, where you are the principal designer, it will include establishing and operating a system for doing this and should include scheduled regular reviews and checks of the design. And there's a requirement that any mandatory occurrences must be notified and reported to the building safety regulator within 10 days. So that window of opportunity in of itself creates an additional risk. So moving on to additional risks then, what additional risks are created by the BSA? So designers are now held responsible, not only to their client under the terms of their appointment, but also under the statute and regulation to the building safety regulator. So that's to ensure their design is compliant and all applicable regulations rules, so with all applicable regulations and rules, and is suitable and safe for the intended purpose and is fully coordinated with the others working on the project. So as recorded on this slide, what are the additional risks? So there's the risk of non-compliance with building regulations. Well, you might say that's not new, and well, that's right. But there is now increased scrutiny regarding compliance generally, which would include compliance with building regulations. And so the increased scrutiny causes that to be a heightened risk. Because of the additional requirements for coordination, any poor coordination is a real risk. And as I said earlier, I think this is a big risk area, given its reliance upon third parties engaging with each other properly. Because of the requirement to keep accurate records, the lack of any record keeping or traceability creates a significant risk. And that's not only in relation to the golden thread, but also in relation to keeping and preserving evidence of coordination and occurrence reporting. So there's going to be a real need for increased focus for everyone on record keeping, proper revision control of designs and so on. There's a risk of negligence, which again has always been there and is nothing new. But there are now greater regulatory burdens which hold everyone to account. And I'll come on to the potential penalties later. So as a more general point, there is now much greater focus on compliance. And so in theory, there is now a greater risk of claims being made. However, hopefully the potential increase in claims will be reduced by reason of the standards in the industry increasing due to the more onerous and exacting standards brought about by the BSA. Of course, the stated purpose of the legislation was, after all, to improve standards. And so if, as hopefully will be the case, standards improve, claims should also reduce. So these next two slides cover the various new responsibilities, and forgive me, they are slightly repetitive, so I will canter through them. But the BSA introduces or reinforces the duty of care, which of course was always there, but structural engineers must now prioritise safety by reference to the structural integrity and fire safety. There's a greater focus on competence, which now requires that designers must prove their competence. And at my next slides, we'll consider how this is to be achieved. There's greater emphasis on documentation and reporting. And again, there's now an increased focus on visibility and record keeping, and documents must be available for inspection upon request by the building safety regulator. There's a greater requirement to collaborate with others. And so there's a real focus on the requirement to collaborate with the duty holders. And as I've said, this, I think, creates a real risk. There's a requirement for regulatory compliance. And again, whilst that's not new, there are now more regulations with greater scrutiny. And accountability. Again, this is not new. Structural engineers have always been accountable for their work, but there's now an increased focus on compliance and sanctions in relation to the same. So how then do we mitigate risk and demonstrate compliance? Well, with regard to demonstrating compliance, there's really two key methods to do this. The first one is by training, be that formal training or accreditations, and making sure you keep records of that so that you can refer to it in the future if you need to demonstrate that competence. Alternatively, you can refer to examples or portfolios of previous work which demonstrate specific action and outcomes related to building safety. When considering the principal designer role, their competence is governed and benchmarked by PAS 8671, and it includes behavioural competence, regulatory competence, and a technical framework for compliance. So how then construction engineers mitigate their exposure to this additional risk, which they are burdened with by virtue of the Building Safety Act? Again, to repeat myself, the requirement to obtain clarity on your role within the project and to know what your specific duties are is key. Make sure they are properly recorded in your scope of works and appointment documentation, and take care to bottom this out at an early stage. There's obviously a requirement for there to be design compliance. Obviously, you need to make sure your designs comply with the specification and all applicable standards, but do involve additional specialists to assist you if needed. With regard to the golden thread, this is required for higher risk buildings, but also good practice generally. But good record keeping is the easiest way to prove your compliance if ever questioned. The biggest issue we see on projects, when considering golden thread or not, is a lack of records. And a lack of records makes it extremely difficult in a dispute situation to either defend or advance claims. There's a huge focus on collaboration. So there needs to be a focus to be thorough on this. And again, to keep a clear audit trail around collaboration, because this could, to my mind, be an easy way to expose yourself. So to keep a clear audit trail, which records who is doing what and keeps a record of it. Insurance is as important as ever. Make sure you're insured in the context of the project and your appointment. So I recommend you liaise with your broker to ensure you have the correct cover for higher risk buildings. In particular, as a structural engineer, you'll often have to provide collateral warranties to other third parties. And so you must ensure that you have sufficient PI cover in relation to those specific warranties. And you must stay informed by attending CPD courses and training to stay informed about regulatory changes and to improve your skill sets and knowledge, and importantly, to keep a record of that training. So moving on then to enforcement. So new regulatory bodies have been introduced, and the building safety regulator is the main one. But there's also a regulator for construction products and an ombudsman for new homes. But the intention is for the building safety regulator to carry out the functions listed on this slide. And the role is basically to oversee all the new processes which have been discussed today and to take the necessary enforcement or investigatory action where needed. It's been widely reported in the news the issues the building safety regulator is facing, and in particular, it's failing to keep up with the demand on the Gateway 2 applications. And the chief, Philip White, stepped down recently. And following that, the HSE has been stripped of its responsibility governance for the building safety regulator, and it's been handed to a new government agency. And we're yet to see what impact that may or may not have. So with enforcement in mind, it's worth considering what penalties there are. And what do those penalties look like? Well, this slide here provides a summary of what those penalties could be. And they're pretty serious. They include criminal and personal liability for non-compliance. And I've seen in the news in the last week or so that a construction company has been fined, I think it's £165,000 for fire safety failings on a project in Preston. So the building safety regulator is obviously starting to enforce the new regime, and fines are being dished out. As to criminal enforcement, it remains to be seen what appetite there is for any criminal enforcement. However, if criminal enforcement proceedings are brought against a construction professional and those proceedings were successful, it would undoubtedly encourage civil claims and would make defending such civil claims extremely difficult. And because of that, it might be that insurers seek to exclude any claims where there has been a finding of criminal liability against a construction professional. So aside from claims arising directly out of the Building Safety Act, what other claims might there be? Well, they are broadly the same as they ever have been. So civil claims outside the regulations to include claims under appointments for breach of contract, claims under the Defective Premises Act, and claims in negligence. But as referred to above, there's a significantly increased potential for such claims being advanced given the extended limitation period under the Defective Premises Act. And as I said earlier, as found in URS versus BDW, a negligence claim arising under the DPA is the subject of the extended limitation period. And with regards to contractual claims generally, it's important to know what terms you're signing up to. Check out for any unusual terms such as fitness for purpose obligations or other non-standard terms like that. And generally, breach of contract claims are potentially more likely given an appointment is almost certainly now going to include an absolute obligation to comply with your duty holder obligations under the regulations, and because of the generally much heightened scrutiny and awareness of standards. So sadly, it's not possible to contract out of the Building Safety Act or the DPA related claims, and so you can't exclude liability for them under your appointments. So in summary, therefore, the BSA undoubtedly significantly increases the risk profile for structural engineers. The combination of the new duties, extended limitation periods, and stricter safety regulations may lead to more claims against engineers. For structural engineers to mitigate these risks associated with the Building Safety Act, it's crucial to prioritise early engagement with the project team to understand what role you're to undertake, to invest in robust design processes, to ensure clear communication and documentation throughout the project lifecycle, and for that communication and documentation to be kept, and also to identify when higher risk building work is to be undertaken, and implementing effective risk management strategies, and generally fostering a culture of safety accountability within the team. But as I referenced earlier, let's hope that the increased regulation does what it's intended to do, that is to improve standards. And if those standards are improved collectively in the industry, I hope that of itself will reduce the risk of claims.